be seated. Okay, good morning. We have one case left on the docket this morning, Thomas Home Corporation versus Grand Oaks. Counsel for appellant, you may proceed when you're ready.
Good morning, may it please the court. Todd LaDucer on behalf of Thomas Home Corporation. I'd like to reserve 3 minutes for a rebuttal, and I'll try to watch the clock here as much as I can.
So noted.
Thank you, Your Honor. Again, I represent Thomas Home Corporation. That company owns 9 lots in the subdivision of Grand Oaks. It's Grand Oaks Farms, first edition, but Grand Oaks is the subdivision name. That subdivision has an HOA. The HOA purports to have an ARC, Architectural Review Committee, which is in charge of looking at plans and additions and things like that to go through all of the, you got the grass in the right place, you got this many bushes, all the stuff that HOAs do along the way. My client owns 9 lots. He started buying them in 2005. He has submitted plans, in this case, on 2 different occasions and received rejection letters that gave virtually no reason as to why they were rejected. He was told by members of the ARC that he was not the kind of guy who could build in that subdivision, that he was not allowed to do that subdivision, that they told, some of the members of the ARC told a previous builder, owner of the lot who was trying to build multiple lots, that they didn't allow people to build on multiple lots. And that if he tried to build on a multiple lot as a tract builder, they would spend the $72,000 in their war chest to keep them out.
Based on your review of the covenants and the guidelines, do you think there's a dispute as to whether the plans submitted by your client were not complete and not compliant?
Absolutely. Absolutely, and here's why.
Okay.
Number one, before we even get to that issue, the ARC, as a subcommittee that makes decisions about building and architectural issues of that, is governed by the statute that forces it to give notice of its meetings, to open it to the members of the HOA. It is unrebutted and virtually admitted that there was no notice posted as required under the statute for either of the 2 meetings that occurred for my client's consideration. My client had no idea when these meetings were going to take place. Both of them, the statute is mandatory. And I've submitted a case to the court that says that when you don't notice a decision like this, the board of directors, clearly, that's a typical thing where you have to notice that board of directors. It also includes committees that do architectural stuff. That's
Weren't there certain documents specifically required to be submitted by the covenants?
No.
Okay, it was only by the Architectural Review Committee?
Well, there's 2 separate things from that. Yes, that's right. And my first point about these architectural review guidelines that I've noted and I've argued below and I argue above here, they're unrecorded, unsigned, and orally changed but not modified so that no one knows what is in those guidelines except the people on the ARC, which is an invalid body that I'll get to in a minute.
Now, the guidelines, though, that were effective 2005 that were provided at closing, are you contending that those are no longer the guidelines in effect?
Yeah, absolutely. Now, I'm not contending that. They admitted that it wasn't because there were changes that are only in the minds of the ARC. So that document in 2005, unrecorded, which is going to be important in a minute, does not reflect any of the changes that the ARC made to it over time. So there is no written document of that stuff. I read to the court 72303-1. An association after October 1, 1995 must be incorporated and the initial governing documents must be recorded in the official records in the county in which the community is located. Governing documents. If the HOA wants those ARC guidelines to be governing documents, the bylaws are in 2005, they say it's June 2005 for the ARC guidelines, they have to be recorded pursuant to the statute. They are not recorded pursuant to the statute. They're not signed. There's no idea what it is.
Okay, these are all claims that were based on your attempt to amend the complaint. You did not make those complaints in the original.
I did not know those answers, and here's what happened to this. So we go forward, and I take the depositions of the ARC board members, and I learn a lot of stuff. 1, I learned there's no notice. 2, I learned there's no minutes. 3, I learned that these things are not recorded along the way, and they believe that they govern what an owner has to do. 4, I learned that the members appoint themselves, which is totally in conflict with the covenants. I also learned that there's a member who doesn't own any property in the subdivision. A member is a defined term under the covenants. A member is an owner. You have to be an owner to participate in this kind of stuff. It makes no sense that somebody who doesn't live in the neighborhood or own the neighborhood can make these decisions. I learned all of that during the depositions. So the court is correct about that. Those were not my initial allegations because I did not know those at the time. But at summary judgment, we made all of those arguments to the court below.
Okay, if we uphold the court decision here, can you raise all those issues in a new lawsuit at this point?
I'm sorry, say that again, sir.
Okay, if we uphold the decision of the trial court that waiver did not occur, basically, can you bring all those allegations again in a new
No.
lawsuit? Why not?
Because the court, they can reconstitute the board. They can make the ARC, they can do the appointment correctly. They can do all this stuff to do that. They can give notice. They can cure all of the problems that happened with my decision. What the lower court did was say, as a matter of law, the ARC's decision is correct. That is absolutely false. I'm not suggesting that I should say, even though I may be able to, that as a matter of law, it is not correct, right? But I'm just saying, as at least with regard to what we're doing on appeal here, it is not as a matter of law that that decision is valid, given all of the things that I made, that I alleged at the time, that I learned through discovery. An invalid board that picks itself, that violates the very article that it's trying to enforce, is not valid. Once you get to no notice, you stop. No notice. I gave you the case that says that once you do that, whatever happens, and it doesn't matter what was submitted, what was said, how it was done, where it was done, anything, without proper notice, which is mandatory under the statute, those decisions are void. They have to go back and figure out something like that. So what I'm suggesting to the court is that the lower court said, as a matter of law, this is right. I'm almost saying, as a matter of law, it's wrong, but I'm at least saying that there is clearly, it's not as a matter of law correct. Let's just go back and figure this out along the way. Because, and to make your point with that, they can go back and do all this other stuff. They could amend the articles along the way. They could change the covenants along the way. So when we apply at the time, they could change the rules altogether. So that's the point that I have here. Moreover, I have evidence. Secondly, the court weighed evidence. The court weighed evidence, treated it like a bench trial. We were there in a courtroom. Now, that's not dispositive. You can do it in a courtroom. Full gallery, demonstrative aids. They used demonstrative aids over my objection. A demonstrative aid is what? It is to aid the trier of fact to decide the facts. That's straight out of the Horn book. That's what demonstrative aids are for. The court took demonstrative aids. The court then weighed one of the 3 options as to why it was denied. There's 3 versions. 1, the documents, there weren't enough documents. Well, we didn't submit enough documents. 2, the documents violate the covenants. And 3, Thomas Henry just can't build in this stuff because he's not the kind of guy who can do it, and we'll spend all our money to prevent you from doing that. 3 options. The court picks 2. The court says that I think that's the valid
Let's assume you're
construction.
right. How could the trial court allow you to amend the complaint when all complaints were required to go through mediation?
Here's the point with that, Judge. It is not a derivative action. We've argued that. The case law on that comes right over to the Deluro case, however you say that talks about that. You have to have 2 things. That court goes through the analysis. You have to have direct harm and special injury, or a special contractual statute duty away from the defendant. The amended complaint is 3 counts. The amended complaint, count 1, is the same count that was in the original complaint, just beefed up with these additional allegations that I learned through discovery, which is totally normal. That's what happens in litigation every day. That's number 1. Number 2, breach of fiduciary duty of Kevin Wyndham, who is the president of the association. He said he was the spokesperson for the ARC, but he's really the chairman of the ARC. Breach of fiduciary duty to him, and then a declaratory judgment that during the time that Thomas Henry was doing this stuff, the ARC was not a valid body because it was not elected or appointed properly by the HOA. So the only claim that's different is the deck action and the breach of fiduciary duty. You go to footnote 4 in the Denuro case. Law's always in the footnotes, right? So you go to footnote 4, and it talks about how Denuro potentially may have been able to maintain a direct action for breach of statutory fiduciary duty. So the breach of fiduciary duty case doesn't need to be mediated ahead of time. Number 1 was waived. They actually moved to abate or to dismiss the case originally and then said, no, mediation won't be fruitful, so we didn't do it. And then the third one is a declaratory judgment only about Thomas Henry. Nobody else is affected by that complaint except Thomas Henry. Thomas Home Corporation. No one else is affected by that. No one else is seeking to build. There aren't any other decisions that are being challenged. And the time that we're talking about the ARC being ineffective is during the time when Thomas Henry submitted plans. So there is no need for that. Moreover, even assuming the court is correct, assume you're correct, Judge Wolf, that it needs to be mediated. The proper mechanism is to allow the amendment, abate the case for the mediation, and then go forward. Not grant summary judgment as a matter of law and then make everybody go back to the starting point. That's the proper way to do it. In fact, Grand Oaks filed that very motion at the beginning of the case. That's the proper way to handle that. So even if the court is correct, and again, I respectfully disagree with that, but even if the court is correct about that, the proper mechanism is to abate and then move forward that way. Not grant summary judgment where you're weighing the evidence and picking it. The court found the state of mind of the ARC members. Those are all questions that come up at a trial. The judge may be is going to be the trier of fact in this case. That's fine, but you don't do it at the summary judgment phase. You don't do it at the summary judgment phase to wait.
I'd like to give you an opportunity to respond to the motion for sanctions and your
Yes.
response to that. So I think the argument is, that there was a frivolous claim.
Right.
And you've countered that there was an argument in the trial court that this was a very complex case with very involved issues. And so is it the case that a complex case could never be frivolous?
I don't think that's true always. Well, I don't know. I think so, yes. If it's so complicated and it complicated in fact and law is what the lower court found. They argued that below to get enhanced fees along the way and stuff like that. And so that's what the court found, facts and law. If it's just complex in facts, someone called my dog a bad name and I make up this big story about how they called my dog a bad name, okay, well, legally that might be frivolous because there's no such thing as defamation of an animal, right? So in that case it could. But when you have a complex issue involving fact and law, I would respectfully say that no, you cannot have a frivolous action with that because there's the definition of what you're doing. So I think in that regard, no, you cannot. Moreover, to use some of the statements that I said, I literally in the deposition tell everybody the only people who win in litigation are lawyers. So it's not that I want to win to get money. It's I'm telling the clients, why don't we settle this case? Why don't we go forward and get a resolution instead of going on and be in front of this esteemed panel to where I get paid to do that. That's my point in saying all of those things. My point about saying it was employment is exactly right. This should not be a vendetta against my client by his client that we pick up and the lawyers then engage in that. Those were my points exactly. That it is nothing about, look, I got plenty to do. I'm not just doing this to milk a file. I've represented Thomas Home Corporation for over 20 years. Our sons played baseball together. I'm not doing this for me. And in fact, all of the statements I was making was trying to work this toward a resolution instead of saying, oh, we're just a small HOA, we want to get rid of this. Then mediate. Don't say mediation is fruitless. Then work with us and try to get this done. Not go all the way through this and end up here. This is the exact opposite of trying to do that. So I take very distinct issue with the sanctions motion on this. Lastly, I would just like to say the ARC is invalid. The covenants of 3 require the HOA to appoint the members. It is clear that did not happen. They appointed each other. And for the amendment, it's not derivative because of what I said, and I would like to reserve my time. Thank you.
Hey, please, the court, I'm Ken Bell on behalf of Grand Oaks Homeowners Association. In addition to just, this case is like playing whack-a-mole. It changes, the argument changes every time, and we have pleadings that say what the pleading. The pleadings of this case was Thomas Holmes submitted plans, the plans were rejected, and the decision to reject was arbitrary and capricious. Why? It's demonstrated solely because the Homeowners Association wasn't enforcing unrelated restrictions in 3.4, not 3.2. The cause of action available to Thomas Henry was 720.3035, which covers architectural control covenants, parcel owner improvements, rights, and privileges. And under subsection 4 of that statute, what their cause of action was to bring, after mediation, an action to prove that the Homeowners Association's action was unreasonable, knowingly, and unreasonably, knowingly, and willfully infringed upon Thomas Henry's rights. They never filed that. They filed something that is unknown to Florida law. They tried to declare it a breach of covenants, which would require a material breach in the covenants. They don't even allege that. They argue basically waiver, but don't even call it waiver. And what really gets me to your question of the umbrage, the reason mediation was waived is because I wrote letters and I called and I got no response to the requirement for mediation. So I filed a motion to dismiss. One of his associates showed up at the hearing and I said, can't we resolve this? Why don't you just submit another set of plans? That wasn't an option, so I said, okay, the cause of action as pled is frivolous, so let's just do a little bit of discovery. We'll waive it if it's going to be fruitless. And so that's what happened, and when the court entered it, they said, the parties shall proceed under the current pleadings and without being required to mediate. That language is in there intentionally because I knew that those current pleadings had no basis in law or fact, and I didn't want to get suckered punched. But then he says, why don't you settle? We go to the case management conference before Judge Bowles. Judge Bowles says, can't y'all work this out? And I said, yes, all he has to do is submit plans. That didn't work. So we go through a bunch of discovery. And everyone
I
of
think
the
I'm in
ARC...
kind of wonderland here. I keep on hearing about all these attempts to settle and all this. It seems to me, and I'm only speaking for myself, you got a good argument to be made about the waiver. What I'm trying to get my hands around is something comes up in discovery that may or may not lead to a decent cause of action. Wouldn't it be prudent, rather than having two causes of action filed, to abate, let those claims be mediated, and then allow the claims arguably to go forward?
One, I think that could be a reasonable decision for a trial judge to make. That issue is an abuse of discretion, though. And I don't think you can find the trial court abused its discretion by not doing so in this case, because they said the case was ready for trial, asked for a case management conference. We had a case management conference, and at that case management conference, the judge entered an order setting up the schedule, that within 5 or 6 months, there was going to be a resolution of the claim that was filed. And it said the defendant will file a dispositive motion. This was a March order. So in May, I had to file a dispositive motion. I filed it. They had 76 days to do their discovery. And the discovery was supposed to be limited discovery directed to the merits of that motion. And he went way beyond that. Secondly, he would file a response to the motion. We'd file a reply. We'd have a hearing, and it would be resolved. That's the way it was set up. At a case management conference, there was no objection to that order, no request to modify it until afterwards when he went and did discovery on other matters and didn't limit discovery to that. So it was very prejudicial to my client because they're having to do special assessments to pay for their attorney's fees to fight this frivolous case. And they waived mediation only on that one claim because I knew it was baseless. They didn't waive, I didn't waive, didn't have the authority to waive mediation on derivative actions and other claims about the management of the associations and all of that. None of that was waived at all. So summary judgment was proper in this case on the claim pled because there wasn't standing, because he hadn't, one of you asked earlier whether the documents required by the covenants and the guidelines were provided, and they weren't. That issue was undisputed. The filings made were contrary and in conflict with the covenants. If the ARC had approved it, they would have been violating their fiduciary duty to all the members of the association.
Okay, which of the documents, I asked this question of the other side, and I was trying to go through real quickly through the covenants. Which of the documents that were required by the covenants, not by the Architectural Review Committee, because I know the covenants say they can require other documents. He's challenging the legitimacy of that. Were there documents that were specifically required by the covenants that were not provided?
The issue with the covenants is the documents provided were providing for construction, there were 4 items that were contrary to the covenants: the ceiling heights, the soffits, there were 4 items listed in the affidavits and found by the judge, and it was undisputed that the documents submitted were calling for construction in violation of the covenants. The ARC would have violated their duties if they would have approved it. The other 8 deficiencies are in the architectural guidelines, as Judge Ray said, were in the architectural guidelines that were that were adopted in 2015, and they don't have to be recorded. They only have to be published, and that's what 723.035 refers to. It refers to several times to covenants and other published guidelines and standards authorized by the declarations of covenants. And these covenants authorized those guidelines, and those guidelines were published. They were given to everybody who closed, and there was Thomas Henry never denied having a copy of those guidelines. He just said, I probably should have read them, but I didn't. So those documents, he did not submit the documents that were required. The documents he submitted were in violation of the covenants. So the ARC did not have the documents it needed in order to do its fiduciary duty to all the members, and as it has done to everybody else who has applied, is to apply those covenants and guidelines.
Okay.
But I don't want to get off.
You told me the documents that were committed.
Sir?
You told me you gave me examples that the documents that were submitted that violated the covenants. And I'm trying to get in my mind the documents that were deficient.
What I'm saying, the documents that he did provide, like when they showed the garage height,
I understand. That part, that's not my question.
Okay.
But part of this is that he was denied because he did not submit sufficient documentation.
As provided by the architectural guidelines that were
By the
published.
architectural guidelines, okay.
Yes.
Because that was not required by the covenants. That's what it was.
Right, exactly.
Okay.
Yeah. The covenants say the ARC can adopt guidelines. They adopted those guidelines in 2015. And it's a red herring saying, well, they changed in their mind and whatever. That's not the documents.
I appreciate all that. I was just trying to get it straight in my mind.
Yeah, you have the covenants and then the architectural guidelines. In order to do a 2-step process, there's a preliminary review, and once you pass the preliminary review, then you go to a final review. The purpose of the preliminary review is to give the ARC all the documents they need to make sure that the initial plans are good. Then they send it to an architect to review the final plans to make sure it's all consistent and appropriate. He never made it past the first stage because he never submitted the document. That's why in the letter that he got from the Homeowners Association, the ARC, it says if you apply again, you have to have all required documents as listed in the controlling documents, including but not limited to full landscape plans. But again, that's way off course, because what he pled was the arbitrary and capriciousness was demonstrated by non-enforcement of not Section 3.2, which is the one at issue, but non-enforcement of issues on satellite dishes and a flagpole and these other things, which it's undisputed in the file by the affidavit and otherwise that those didn't exist, and any that may have existed didn't go to the level of Mazzell and the others to not allow you to enforce the construction guidelines.
I'd like to clarify, I think your answer to Judge Wolf's question on do the covenants require particular documents? You know, in the deficiency letter of February 2nd, 2017, and I think in the second one, it identifies as deficient the lack of full landscape plans, color rendering of elevations. Both of those items appear to be required under 3.2B of the covenants themselves, proposed clearing and landscaping elevations of all improvements. So aren't those requirements expressly part of the covenant? And you're not abandoning that, are you?
Oh, no.
Okay.
The covenants, I didn't remember exactly what documents the covenants required, and I remembered as we listed in the affidavit and as was found in the judge's order, we listed the deficiencies from the guidelines and then the deficiencies from the covenants. But all those documents were not provided either.
And so if the proposed plans were out of compliance with the covenants themselves, it doesn't really matter about any meeting deficiencies or, you know, the ARC composition, et cetera. I mean, this is required by the covenants themselves.
Yes. And the other thing about the meetings and all this other stuff, he spoke, but I think under Leopard and under IEZZI in those cases, those are clearly derivative actions. And he argues, well, couldn't you go back and do that? And then they said, well, they could correct that. That's exactly why you have those as derivative actions. You bring it to the attention of the corporation that there are deficiencies in the management of the corporation, and the corporation looks at it and it can ignore it, then it can file suit, or they can fix it. That's exactly what the statute is meant to do. And secondly, you still have to mediate it. 720.311 requires mediation of that type of dispute, expressly requires the mediation, and that mediation did not occur. It says disputes between an association and a parcel owner regarding use of the parcel, common areas, or other covenant enforcement disputes, disputes regarding meetings of boards and committees appointed by the boards, membership meetings shall be the subject of a demand for pre-suit mediation served by an aggrieved party before the dispute is filed in court. The association has the right to have those proposed new claims mediated before the suit is ever filed. And for them to stand up and say, well, we didn't do mediation as we should have the first time, you filed a motion to dismiss and you said, okay, we'll waive it for this and we'll go to summary judgment on the current pleadings, then come back and completely, as Judge Miller found, file a completely new lawsuit as an amended pleading, and then say we waived the mediation. Waive that right to have those issues go to mediation is absurd. So I think you should affirm what Judge Miller ruled. There was no viable cause of action originally filed. And if you look at our response to the motion to amend, I attached to that a document that I took the original complaint and then I put in bold letters the changes that were made and made notes on the side of how the language was changed. And that was available to Judge Miller. I ask you to look at that if you have any questions. But the key change they made to the first count, they didn't just add stuff. Instead of arbitrary and capriciousness, they said defendant HOA's refusal to allow Thomas Home to build the proposed house is improper. And it was improper because they didn't appoint properly or didn't notice properly, didn't manage the corporation properly. That's completely different from the cause of action originally pled. So summary judgment was proper. There was no, even if you accept that there was some cause of action for the association's disapproval of the deficient, inadequate plan was arbitrary and capricious because they weren't enforcing specific restrictions in another section of the covenants. Even if you accept that argument, there was no proof that those occurred to the level required by law. So summary judgment was proper there. Denial of leave to amend was proper because there's three things you look at. Whether it's prejudice to the opposing party, abuse of the privilege to amend, or futility. And Judge Miller said there are two independent grounds to deny the amendment. One we haven't discussed much and I don't have much time is futility. They didn't meet the pre-suit requirement. They didn't have standing in the first place, and they didn't do the mandatory pre-suit mediation required independently, but also for derivative actions. Thank you for your time.
Thank you.
Thank you. Going in reverse order. It is not a different case. It is the same parties. We're talking about two decisions that they made in February and March. That's all we're talking about. Why was that denied? Certainly you can fill in and color the coloring book with colors now as you go through discovery, but it remains the same two things, same parties. Moreover, I just read to the court, the breach of fiduciary duty claim doesn't have to do any of those things. It's not a derivative claim. So at least that count in the amended complaint has nothing to do with anything, and there's not even an argument that that has to be mediated, that you couldn't amend to do that. Moreover, I gave the thing with the that we meet the test, that we have a special injury, and we've done that along the way, even if and we do have a contractual right to sue. It may not be special, he may be right about that, but we don't even have to get to that exception because of that, what it was. To talk about that the guidelines control and that they don't have to record them is just simply wrong. The statute says that if you want to use, the statute says governing, you just read it, it says controlling documents. You need to be governed by the controlling documents. Controlling is just a synonym for governing, and I just read that statute, 730, 301, 303, 1. They have to be recorded, and that just makes sense. You can't have these rules that govern real property that are secret when you're going to buy the real property. They have to be recorded so that everybody's on notice that, hey, look, this HOA right here requires 20 roses in your front yard instead of 3, requires a house of 5,000 square feet instead of 2, requires all of that kind of stuff. That's why that's important. So you cannot rely on those things along the way, let alone the oral, the changes that they make that they don't do that. Also, an invalid ARC that violates Article 3 of the covenants has no right to enforce anything in the covenants because the very article that they're looking to enforce, they are violating themselves. The HOA and the ARC are violating Article 3. Everything here runs in Article 3. There's A to double C or something like that. A to Z to double C all the way through all that stuff. Those are all the things that are in there that they're looking to enforce. There's a satellite dish that they said they ordered a variance for. Of course, it's not in writing. You're required to have it in writing. They violate that stuff. That's not even the major point. The major point is through discovery. They violated by having non-members decide ARC matters. The ARC was not valid in of itself. And then 3, they don't notice it or do it on any property like that. Once you don't notice a meeting, all this other stuff about what was submitted, moreover, I would just say this, and I know I'm over, is the ARC has the ability under the covenants to basically vary and change any of those requirements, any of them. So to suggest that they're somehow breaching their fiduciary duty is wrong. They can do it, they literally have super broad powers if it's properly constituted and run right, that they can waive any of that. So you could submit a napkin and they'd say, hey, that looks good to us, great, good to go.
Thank you,
Thank you.
counsel.
Thank you very much.
We appreciate
your
both
time.
arguments of counsel. The court is adjourned for the morning session.
All rise.